So on the 23rd of July, so less than 2 weeks ago, 15 members of the International Court of Justice, or the ICJ, the acronym, delivered their unanimous advisory opinion on the obligations of states in respect of climate change. So this is a picture from the court's website of the 15 judges. You can see them there up beneath that amazing set of windows in the International Peace Palace in The Hague in the Netherlands, where the ICJ sits. And this is them delivering their decision. The president at the moment is from Japan, and there are judges from all around the world. So there was a fabulous judge from China, there was a fabulous judge from Australia, from judges from all around the world were part of this decision, and it was unanimous, so they all agreed. And there was a lot of news about it, in that 10% of news that doesn't relate to crazy people in the United States and all that stuff, and wars. But there was a lot of news about the World Court basically making a massive step forward in relation to climate obligations of states, and the implications for countries like Australia, which are major greenhouse polluters and major emitters and exporters of climate pollution, are enormous. And this article from the 26th of July on ABC News, capturing really the essence that it's expected to unleash a new wave of climate litigation against countries like Australia. So a bit of historic context for this, because this is truly historic, and the nub of that history is we've had 30 years of failure of international negotiations and action on climate change. So the graph on the right of this slide shows carbon dioxide levels in the atmosphere from about the 1960s and climbing up from less than 320 parts per million to now over about 420 parts per million. And then the colour bars represent increasing temperatures as well, so mean global temperatures. So you can see them increasing steadily across that time. And overlaid on that are milestones in the international negotiations around climate change. So there's been an unrelenting rise in atmospheric CO2, while industrialised countries knew of the harm, but largely continued business as usual, expanding fossil fuel use, denying legal responsibility for the harm, and stifling international agreement to stop and pay for the harm. So in 1992, there was an international convention called the United Nations Framework Convention on Climate Change, where the international community agreed climate change is a big problem. We need to do something about it. It was a framework. Then in 1997, there was this agreement signed in the Japanese city of Kyoto called the Kyoto Protocol to the United Nations framework, and it set some targets for industrialised countries like the US and Australia to limit their emissions within a commitment period a decade ahead of that time. That led up to 2009, where countries couldn't agree on a second commitment period and targets, and the US and China basically had this massive blame game, blaming each other, and it just ended in this dismal failure in Copenhagen. But then in 2015, the international community had this success in Paris of the Paris Agreement, so setting targets to stabilise mean global temperature rises beneath 1.5 or 2 degrees. And then a few years ago, about 5 years ago, students in university in Vanuatu were set a task of what could they do, because CO2 levels were rising, climate change was impacting on countries like Vanuatu and the Pacific. What could they do? What legal options were there? And they thought going to the International Court of Justice for an advisory opinion was a really good option. And that was picked up by the Vanuatuan government, and then the Pacific, and then essentially the Global South came on board, leading to a resolution in the United Nations General Assembly requesting an advisory opinion from the International Court of Justice. So the UN General Assembly and the ICJ were set up in the aftermath of World War II. Don't hear a lot about the ICJ until this point, but this is a massive breakout decision for them. So the General Assembly requested an advisory opinion, it's just been delivered. And
sorry, may I ask what an advisory opinion doesn't sound very...
That's a really good point. An advisory opinion doesn't sound very important. Without getting into the technicalities of why it's an advisory opinion only, it doesn't technically... Essentially, the way it's been given as a 15-member unanimous decision has pretty well decided the obligations at a general level of climate in relation to climate change harm. And it clearly applies to countries like Australia, but it doesn't specifically identify Australia and say you are liable for $3 trillion to countries in the Pacific. Those cases are going to come. So there will be claims against Australia and against the US and against other countries for the harm they've caused. This is I say the first step. This is a massive leap into that liability. So don't be misled by the fact that it's only an advisory opinion. The nature of this decision and who has given it is a resounding declaration about what the law is, but also it's sort of shifted from what countries like Australia and the US have been doing and Saudi Arabia have been doing for 30 years, is denying responsibility, saying, yeah, climate change is a problem, but we're basically going to continue business as usual. We'll set some targets. We'll give a little bit of money voluntarily for aid for countries that are impacted, but we don't have any legal liability to avoid this harm or to pay for it now. And what this decision has said is, no, it's not voluntary. There's a duty of care, it's stringent, and you have liability if you breach it. So this is an amazing decision. So during the past 30 years, Australia has massively expanded its coal and gas exports, often after extensive environmental impact assessment, recognising the reality of climate change. An example is the Adani mine approved in 2016. If you're in the first semester course, ENVM 3103 or 7123, dealing with regulatory frameworks, I gave a lecture about the Adani mine back in that course, but essentially it's this massive coal mine in central Queensland. So that's an example of something that was fully assessed for climate change impacts and yet approved anyway. So some key findings from the ICJ include, so the Paris Agreement said that the goal is to limit mean global temperature rises beneath 2 degrees or, if possible, beneath 1.5 degrees. And the ICJ has said, well, the scientific consensus is 1.5 is needed, and that's become essentially the global consensus now. So that is the goal, that is the legal requirement, which is a massive step forward. Also, another big finding is that the international climate change treaties like the UNFCCC, the Kyoto Protocol and the Paris Agreement do not exclude other international laws, and they rejected. So what countries like Australia were doing was saying, oh, we've got these special agreements. A Latin term for it is lex specialis. So these special agreements that should define our obligations. And why they wanted that was because it requires unanimous agreement of all 190 odd parties to those agreements. So they've been able to reject anything that they weren't happy with. And so they've been able to reject clear liability under those frameworks. So they wanted to say, well, now we've got these special frameworks, they should define the obligations, which would have meant they were able to escape liability. And the ICJ said, no way. There's other general laws, including customary international law, that, for instance, that you can't cause significant environmental harm to other states. So that's been established by the practice of states over decades, centuries. So those apply, and the court accepted that those apply and rejected Australia and other fossil fuel countries like the US and Saudi Arabia's argument about special limitations. And that's really significant because the US has just withdrawn from the Paris Agreement, said we're not bound by it. It never ratified the Kyoto Protocol. And it's basically playing this game that if we don't agree to it, we're not bound by it. And what the court has said is, stuff you are bound by it. These are obligations that apply to you. You can't cause harm to other countries and get away with it. You have legal obligations under international law that are binding. Okay, and then a third big finding is that states have a duty to prevent significant harm to the environment under customary international law, and there is an obligation there to act with due diligence, which is stringent and entails not only the adoption of appropriate rules and measures, but also certain levels of vigilance in their enforcement and administrative control. So, in saying that they have set 1.5 degrees as the binding target that the law requires, beware of the common misconception that 1.5 or 2 degree change is a small change. Like, it's a really common misconception around climate change because, you know, each day, you know, here in Brisbane today, I'd say there's going to be a 10 degree temperature range from minimum to maximum. So we think, you know, 10 degree change, no big deal. It was cold in the morning, but it'll warm up at midday. It'll get cold tonight. Put a jumper on, no big deal. So when we hear, I think, you know, in the general community, when they hear 1.5 or 2 degree change, they think, oh, that's hardly even notice a difference of 1 or 2 degrees in the day. You wouldn't. But what that conflates is a daily temperature change with a change in the mean global temperature of the entire world. And a change in the mean global temperature of the entire world is a massive shift, and it's shifting the entire temperature distribution, like in this diagram. The temperature distribution is shifting across like a big bell shifting it, and it's the extremes that cause the most severe impacts that drive more severe hurricanes or typhoons or cyclones, same you know, tropical storms, drive more extreme bushfires. The marine heat wave that's occurring right now in South Australia, there is this massive algal bloom due to a range of factors, but one of them is this global marine heat wave that's allowing algae to bloom and cause extensive damage to the marine ecosystem. It's lasting for months, costing billions of dollars. That's happening now at current levels, which are we're about 1.5 degree warming above pre-industrial levels now. So we're having extreme impacts already, and it's driven by that whole shift. So a 1.5 degree change is actually a massive change. And yeah, it's the extremes that drive mass coral bleaching of the Great Barrier Reef, bushfires, and many other impacts that the world is already experiencing. So a couple of key findings that are really relevant for environmental impact assessment in Australia is at 427 and 428 of the decision. I'm just going to read them. The failure of a state, so in international law, countries are called states, and not to be confused, in a country like Australia where we have a federal system of government, we have a national government, and then we have state governments which are beneath the national government, and then we have local governments. But when international law, they refer to states as countries. So the failure of a country to take appropriate action to protect the climate system from greenhouse gas emissions, including through fossil fuel production, fossil fuel consumption, the granting of fossil fuel exploration licences, or the provision of fossil fuel subsidies, all of which Australia does, may constitute an internationally wrongful act which is attributable to that state. And then at 428, obligation of states to regulate the activities of private actors is a matter of due diligence. Therefore, attribution in this context involves attaching to a state its own actions or omissions that constitute a failure to exercise regulatory due diligence. So if we assess like a big coal project through environmental impact assessment or however, and approve it, it's a regulatory failure. We can be liable for that regulatory failure, even though the state isn't digging up the mine. Because we've approved it, we are responsible for it as a nation. So these are enormous changes in the whole global legal regime for climate change. So it's a radical and tectonic shift in international law for climate change. And while countries like Australia will continue, it's clear Australia's just going to continue along with its head in the sand, trying to say, or, you know, fingers in its ears, you know, saying, la, 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 I can't hear you, ICJ. It's going to be increasingly difficult for them to, you know, saying that they're not responsible or they're not legally liable for the harm they cause just doesn't cut it anymore. We've got a 15-member decision from the ICJ saying you are, or, you know, countries like Australia can be. So general legal liability has now been conclusively established, and there will be claims for reparations of trillions of dollars because entire countries are going to be lost through to climate change, and we're contributing to it. So Australia contributes, it's about 2% directly, and if you take in account our fossil fuel exports, it's about 4 or 5%. So if you think like a country like Tuvalu, if you value like the country at, say, $1 billion or $2 billion or $1 trillion, Australia is likely to be liable for that 2 or 5% of their damage. So it's a huge amount of money, and that's going to drive a lot of litigation because, money then pays for lawyers, pays for experts. Huge amount of time is going to be caught up now in that. There's a lot written already about the ICJ. There's going to be heaps written over coming months, but a really good article, I put the link in the slides, is this one by two lawyers who were instrumental in the claims made by Vanuatu and running the successful case. So really brilliant lawyers and a really insightful article which just was published yesterday.